Good evening to everyone, and may I request everyone to just put their mobile phones on silent mode, please. So today, as you know, we are gathered here for the T.G. Narayanan Memorial Lecture, and we are very, very happy to welcome Dr. Kalpana Kannabiran, who will be speaking on, in the T.G. Narayanan Memorial Lecture 2024. She will be speaking on the subject of human dignity in the time of Article 21, the long satyagraha for the Constitution as Commons in India. Just a few words about who T.G. Narayanan was. So, Mr. T.G. Narayanan, who lived between 1911 and 1962, was a journalist with The Hindu during the war years. He was known for his coverage of the Bengal famine, the war on the Imphal front, and his interviews with India's freedom fighters. His writings on the famine were one of the earliest instances of investigative journalism. His coverage and analysis were recorded in a book, Famine Over Bengal, and published by the Book Company of Calcutta. After Indian independence, Narayanan joined the UN in New York, and at the time of his death was the deputy and personal representative to UN Secretary General Dag Hammarskjöld on nuclear disarmament at the 18-nation talks in Geneva. The T.G. Narayanan Memorial Lecture on Social Deprivation has been instituted at the Asian College of Journalism by his son, Dr. Ranga Narayanan. Dr. Ranga Narayanan, this is the first time, I think, in 11 years that Dr. Ranga Narayanan is unable to join us, but he has sent a very warm message to all of us. And the first part of the message is a very warm thank you to Dr. Kalpana Kannabiran for delivering this lecture, albeit in his absence. There is also a warm welcome to the audience here, and particularly to our students and all well-wishers and other guests who are assembled here. He wishes you all a very, very happy and peaceful 2025. So let me very quickly introduce our distinguished speaker for today. Dr. Kalpana Kannabiran is a sociologist and a legal scholar based in Hyderabad, India. Over the past 3 decades, she has co-founded and worked with Asmita Resource Center for Women. And she was also part of the founding faculty of Nalsar, which is the University of Law in Hyderabad, where she taught both sociology and law. And she retired as professor and regional director, Council for Social Development, Hyderabad. She is currently Distinguished Professor, Council for Social Development, New Delhi, and has completed a 3-year term as Civil Society Advisory Governor, Asia Region, for the Commonwealth Foundation in London. And this was till December 2022. Just a few details about Professor Kannabiran, who received her PhD in sociology from Jawaharlal Nehru University and an LLM from the Postgraduate College of Law, Osmania University. She was Rockefeller Humanist in Residence at the Women's Studies Program, Hunter College, City University of New York. This was in 1992-93, and is the recipient of the V.K.R.V. Rao Prize for Social Science Research and the Amartya Sen Award for Distinguished Social Scientists for her work in the field of law. Kalpana Kannabiran has also published widely across the fields of law, gender, and sexuality studies and sociology. She has a very widely acclaimed book, Tools of Justice, Non-Discrimination and the Indian Constitution, published by Routledge, 2012. And she also has been, written widely in the Hindu, the Wire, and Scroll, and also published in. This compilation was published as Law, Justice, and Human Rights in India: Short Reflections, published by Orient Black Swan. So I welcome Kalpana Kannabiran to the podium.
Professor Nalini Rajan, distinguished guests and friends, I'm honored to be here, and I thank the Asian College of Journalism for this invitation. What I will present today is part of work that I am currently engaged in trying to understand the Indian Constitution in a more wide and in a more wide and meaningful, shall we say, manner. I have a particular set of arguments of how we can do that. We are privileged to have in our midst sociologists, lawyers, jurists. I'm honored by the presence of Justice Chandru, historians, and it is on the work of people across disciplines that I draw in trying to posit that we need to understand the Constitution and constitutional jurisprudence differently if the Constitution is to make any sense to us. It's not to rewrite the Constitution, but to interpret it insurgently, as I hope to demonstrate through my talk today. I will, for the most part, stay with the written lecture, which you have the text of. And if necessary, I could add to it. The problem, of course, is that where the Constitution is concerned and where constitutional interpretation is concerned in India today, under a right-wing nationalist government, you have interpretations and declarations and misinterpretations being peddled on an hourly basis. And so it is, in a sense, impossible for anyone engaging with the Constitution or desiring to speak on it to have a text that represents the misrepresentations adequately. So I will fall short on that count, that I can't actually keep pace with the level and volume of constitutional misinterpretation by our courts and our judges. And I'm sure Justice Chandru will agree with me on this, because he is one person who has been writing incessantly and pointing out the fallacies of constitutional misinterpretation in courts at every level in our country. Article 21, of course, as we all know, is the right to life and personal liberty. And this is an article that I have been quite obsessed with in terms of understanding what do we mean by life and personal liberty for India. And so in addressing the question of deprivation, the T.G. Narayanan series is on deprivation. In examining the question of deprivation, I quite specifically zero in on the deprivation of life and personal liberty. In particular ways, through the medium of courts and outside. And how do our intellectual histories on the subcontinent help us to think differently and think better about the Constitution? I'm honored to speak in memory of Mr. T.G. Narayanan today. In keeping with his keen engagement with resistance politics and his practice of what I call insurgent journalism during India's quest for freedom, as also his commitment to peace, justice, and non-violence, exemplified in his work with Gandhi and beyond, and his status as a connected critique, which is a term that Paul and Dowling use in their review of his work, I focus on a particular aspect of deprivation, the deprivation of life and liberty, or what we call Article 21 rights, and the dignitarian struggles in free India. We are today at a time when lapdog journalism is ascendant, and nobody more than people gathered in this room will understand that better. More than ever before in need of journalists who are connected critiques and insurgent in their approach to and understanding of social justice. I thank the Asian College of Journalism for this opportunity to share my thoughts in these troubled times. I begin with connected histories. Let us speak of Palestine. We live in a time when the term connected histories carries urgent calls to resistance and collective action in defense of constitutional values in the here and now, within and across territorial boundaries, borders, and fences. I begin with a reference to Mr. T.G. Narayanan's final stint after his career in journalism, his role in the founding of the Indian Council of World Affairs, and his work as a diplomat of the United Nations, deeply invested in the question of peace in the world order. If the Cold War, nuclear disarmament, and peace treaties between the superpowers were urgent concerns during his time that saw his close involvement, today, the most urgent questions of peace and global justice must focus on Gaza, Palestine, and the indefensible actions of the State of Israel. I begin, therefore, with a prefatory note that reflects my disciplinary location as a human rights ethnographer and as someone committed to exploring ideas of justice across the world. No discussion on contemporary history can begin today without an unwavering condemnation of Israel's violent policy of apartheid, its bombardment of Gaza, and its domicide, genocide, and war of extermination of the Palestinian people, and its actual perpetuation and exacerbation of settler colonization, now no longer confined to Gaza. What we have been witness to over the past 14 months is an unprecedented and catastrophic resurgence of supremacist, racist empire, occupation, colonization, genocide, infrastructural destruction, and impunity on an unimagined scale, financed by the Western superpowers, whose own genocidal histories have now paled in comparison to what we witness even as we gather here. I stand here committed to the demand for immediate and total ceasefire, sanctions against Israel, and its prosecution for war crimes and crimes against humanity. We now have an ICC ruling to this effect. Prior to that, the proceedings of the International Court of Justice, and through it all, the delegitimization of UN agencies, especially the UN Relief and Works Agency, that has seen mounting losses and obstacles in their daily work of bringing succor to Gaza, and demand the right of return, the end of Israeli occupation of Palestinian territories, and the right to reparations for the Palestinian people. I draw this commitment from my commitment to the Indian Constitution, encapsulated in the preamble. This is our present. This is a defining moment in contemporary history. Palestine is our lens to a new historical sensibility and humane futures. As the Palestinian people urge us to do, let us shift the axis from the theology of empire, supremacist occupation and dispossession towards a convivial theology of fellowship, dignity, and hope. And in India, we must think of Manipur and the irreparable harms visited on the people of the state over the past 18 months, with guarantees of civic and state impunity for perpetrators of mass crime and collective violence. I present today some general observations that draw on my ongoing work with cases and materials pertaining to civil liberties history from the former state of Andhra Pradesh, now Andhra Pradesh and Telangana, on the subject of the deprivation of life and personal liberty under the Constitution. It is apt to begin a conversation on dignity and hope with a reference to the ways in which Dr. B.R. Ambedkar imagined fraternity and belonging in India. I begin with the reminder that equality, life, liberty, freedom of faith and conscience, and freedom from exploitation and discrimination, the entire constitutional architecture flows from the articulation of the rights of minorities that must be non-negotiable. Dr. Ambedkar suggested in the Constituent Assembly that candidates from the minority community should secure a minimum number of votes, candidates from the majority community should secure a minimum number of votes from minorities in their constituencies, leading Mr. B. Shiva Rao to remark, this would have amounted to a minority exercising a sort of veto on the majority communities. And we know that that is possibly the only road forward today. Maulana Abul Kalam Azad, from Saida Hamid's account, anticipated Dr. Ambedkar's idea on the right to veto when in 1940 he declared, I quote, "Any constitution that's framed in future in India must contain the fullest guarantees for protection of the rights and interests of minorities." What are the necessary safeguards? This judgment on what the necessary safeguards are rests with the minority, not with the majority, and therefore must be formulated with their consent, not by majority vote. Shona Rodrigues traces the ways in which Maulana Azad articulated ethical, moral, and theological arguments emerging from, among other sources of Indian tradition, Islam, on the nature, justification, and critique of a unified rule of law for a diverse people, reinscribing the boundaries of the political, challenging British imperialism, and pointing to the plural foundations of self-rule and constitutionalism in independent India. In my ongoing work, I attempt to build a bridge between the intellectual history of Indian constitutionalism, histories of insurgent interpretation of the Constitution, and the ideas of the scholars of the commons. In proposing the conceptualization of the Constitution as a commons, I look at belonging and ownership, foregrounding collective action and civic engagement as providing the tools for constitutional interpretation. It is at this moment the spirit of constitutional morality, not its narrow legalistic prescription, that guides an interpretation of its protections, its use, and its abuse. I will not have the time today to dwell at any length on the idea of the Constitution as commons, but I will attempt to lead up to it. I begin with questions. Why is it necessary for us to focus on convivialities in India today? Why do we need to think of recuperation by invoking something like the Constitution as commons? The simple answer is to resist and counter the politics of maiming. I draw on Jasbir Puar's work in the context of Palestine and expand its scope in the context of contemporary India. I raise questions to do with post-truth regimes, economic violence, we saw that with demonetization, sexual violence, we see it all the time, and pandemic misgovernance within the larger context of Hindu majoritarianism. I point to clusters around which impunity, state, and civic impunity, fold the secular into the majoritarian religious nationalist as the only expression of the sacral, narrowly defined through homogenized denominational identities. The deathly coils of the politics of maiming in India articulate caste, community, conscience, ethnicity, and gender as reified, unhistorical identities, disregardful of their dense intersections, heterogeneity, and plural articulations across history. The experience of Manipur in the past year and a half, like I said, is a daily reminder of the profound harms inflicted by the politics of maiming. We could examine the politics of maiming in contemporary India in several parts. Today, I reflect briefly on theocratic frameworks of rule before turning to the deprivation of liberty by the carceral state under Hindutva. In speaking of theocratic frameworks of rule, I draw on Professor Mohan Gopal's lecture on theocratic frameworks of constitutional jurisprudence under Hindutva. Dominant majoritarian discourse on citizenship in contemporary India draws selectively and reductively from ancient traditions and interruptions by Muslim rule, folding myth, history, religion, state practice, and social hierarchies together in the construction of hierarchies of citizenship in the present. This finds echoes in constitutional courts, in cases that touch upon citizenship, religion, and belonging in a range of different ways, in effect undermining the constitutional commitment to equal citizenship with sororal, non-binary, gender-fluid fraternity and justice as core values. It also finds curricular articulation through the disembowelment of school textbooks in 2023 and the erasure of Muslim presence and rule in these textbooks, homogenized across dynasties and regions through constructions of what are called the Dark Ages. Hindu mythological traditions, now narrated in linear monotone, are conflated with counter-historical imaginings of the past, completing the erasure of multiplicity, plurality, and syncretism on several levels across several religious orientations and vernacular traditions, even within what may be broadly described as Hindu. Take, for instance, A.K. Ramanujan's essay, 300 Ramayanas. Professor Mohan Gopal has pointed to the rise of the theocratic framework, importantly, in constitutional jurisprudence in India today, and the steady normalization of Hindutva majoritarianism through courts, where we even have a judge of a high court declaring as recently as yesterday that India will have to function according to the will of the majority alone, a sitting high court judge. We have recently witnessed the frenzied assertions and performance of religious faith by the former CJI. The less said, the better. This is also true of legislative bodies. Witness the opulent Hindutva consecration of the new parliament building in May 2023 and the installation of the Sengol from Tamil Nadu with ochre-robed, bare-chested Hindu male priests, presumably Brahmin, cradling the Prime Minister as a symbol of the new Hindu Bharat. This performance of ritual in the new parliament and his consecration of the building of the temple in Ayodhya, both at state expense, and we know now an act of divine revelation, are identical in form, content, and purpose. This convergence and this performance encapsulate several levels of the politics of maiming. We see this turn at work in direct ways to do with denominational concerns at the individual, group, and institutional levels, and in vicarious ways, not necessarily in cases directly to do with religious identity or institutions, sexual violence, economic violence, for instance. The bleeding of theocratic frameworks into constitutional conversations, I argue, is an act of wounding. the infliction of ontological harms and existential crisis that results in the othering of the Muslim, Dalit, Adivasi, Buddhist, Christian, Sikh, trans, queer, communist, atheist, those that do not belong to the Hindu fold, self-avowedly patriarchal, patrilineal, heterosexist, misogynist, homophobic, and transphobic. These communities are thereby outside the theocratic reterritorialization of the nation, creating a crisis in the imaginations of justice under an anti-colonial constitution that in its very framing interrogates multiple colonizations within and without. Spatiocide, to use Palestinian sociologist Sari Hanafi's description from another context, translates the ontological harms into existential consequences at multiple levels that erode the fundamental guarantees against deprivation of life and liberty enshrined in Article 21. Through definitions of national, anti-national, citizen infiltrator, through securitized barricades that surveil entry and exit, checkpoints now within neighborhoods and cities, through the ousting of Muslims, especially from the idea of India, by law, the Citizenship Amendment Act of 2019, and through disappearing the territory of the only Muslim majority state, Kashmir, in 2019, where the state was reduced to 2 union territories directly under the administration of the national government, demonstrating yet another aspect of occupation. The use of bulldozers, Uttar Pradesh, Delhi, and Nuh, Haryana, to raise the homes and commercial establishments of minorities to rubble is a second manifestation of spatiocide. Demolitions and bulldozing is raw state violence. Balakrishnan Rajgopal has used the term domicide, which is also immediately relevant to the actions of the bulldozer Sarkar in India, now under censure by the Supreme Court through its recent judgment. And like I said, it's hard to keep up with the mixed development in cases. In February 2019, the Supreme Court order of the eviction of lakhs of people whose claims as forest dwellers had been rejected under the Scheduled Tribes and Other Traditional Forest Dwellers Act 2006 is yet another instance of judicially sanctioned spatiocide. The area marked for eviction, for the most part, fell under Schedules 5 and Schedule 6 of the Constitution, which are specially protected under the Constitution. This is but one instance of spatiocide with reference to Adivasi homelands. Spatiocide is also visible in the ascendance of the weaponized corporation in coital embrace with the government and the dispossessions it executes with impunity. Descheduling of forests, for example, but even as we speak, the Adani crimes. The rise of the theocratic framework and its consolidation in state formation is an unprecedented aspect of the politics of maiming. Although it must be recognized that even this has a long history of uncountable minor cuts and seepages that admitted the deluge finally. In looking at the carceral state under Hindutva, I have elsewhere argued that the genealogy of civil liberties petitioning and organizing must be constructed through regional and local experiences. For the Hyderabad state, to which I belong, it must include 2 aspects that pertain to the police action of 1948. The first, the unfair trials, harsh sentencing, and extrajudicial murder of communists immediately after independence, 1948-49. Second, the mass genocidal violence against Muslims and the erasure of this history in Hyderabad state, also the same years. I have elaborated on this twin track in another longer essay and will not go into it at length today. Suffice it to say that the inaugural animus towards communists and Muslims that was witnessed in the Hyderabad state during police action in 1948 are dovetailed today into anti-terror laws, TADA, POTA, now UAPA. These laws invoke security of state concerns witnessed in the war on communists in the foundational violence of 1948. They fold security, and this is by the independent Indian government under Jawaharlal Nehru and Vallabhbhai Patel. They fold security of state into law and order and public order in ways that are violative of basic standards of fair trial and the right to life and personal liberty under the Constitution, Article 21. It has not gone unchallenged, and this is the crux of my argument. There has been a civic resistance and a growing movement for civil liberties in the decades since independence, challenging the deprivation of life and liberty of dissenters and survivors. And yet, the demolition of the Babri Masjid in 1992 and the recent utterly regrettable assertion of the divine Hindu hand in scripting the 2022 judgment by the then Chief Justice of India, the Bombay riots and the Gujarat Holocaust in 2002, and its continuing depredations witnessed in the struggles of Bilkis Banu, all followed 2 decades of post-emergency civil liberties mobilization in defense of political dissenters, and 2.5 decades of Dalit civil liberties mobilization against mass caste atrocities, the Kirvenmani massacre of 1968, marking the turning point in the public mobilization around caste atrocities in independent India, as we see through the work and writing of Maithili Sivaraman and Joan Mencher, and the deeply troubling judicial discourse around caste violence that continues today. After the 2019 amendments to UAPA, it has become a weapon to target individual dissenters, especially political dissenters, and those belonging to minority communities, especially Muslim, serving the larger aims of the Hindu authoritarian state. Preventive detention law exemplifies our quote-unquote national life of contradictions, and I'm quoting from Dr. Ambedkar, that is also birthed in this same foundational moment that I'm speaking about. Although Article 22 of the Constitution of India is titled Protection Against Arrest and Detention in Certain Cases, it is in fact a constitutional provision that authorizes governments to preventively detain persons without mandatory observance of minimum safeguards as required under commonly understood principles of the rule of law, despite the savings. A constitutionally sanctioned suspension of the fundamental right to life and personal liberty passed through a quiescent Constituent Assembly and the first provisional parliament, validated by the Supreme Court in the first challenge it faced in the case of A.K. Gopalan. An uncharacteristic equivocation from all notables, ranging from Dr. Ambedkar to Sardar Vallabhbhai Patel to Chief Justice Patanjali Shastri. Anguished equivocation is equivocation nonetheless. This twinning of anguish and equivocation reverberates through the history of this lawless law of preventive detention, both in parliaments and judicial benches, reinforcing the use of coercive force by the state with impunity. At the time when Justice Fazl Ali's dissent in Gopalan versus State of Madras was reinstated by the 2017 Supreme Court in the Puttaswamy case, preventive detention had proliferated under the aegis of the constitutional courts in the country, with an escalation of arrests and prolonged detention under the spiraling list of laws, state and central, that by now authorized preventive detention with scant regulations. So Article 21 had already been de facto defeated. Of the laws framed by Parliament and state legislatures for preventive detention for reasons of defense, foreign affairs, security of state, maintenance of public order, supply of essential commodities and services, all of these reasons can be offered for preventive detention to come into force. But of all these reasons, the maintenance of public order, a vague and floating category, was the one that accounted for the largest number of cases as of 1986. The process was now the punishment. Civic and state impunity bring with them the realization that maiming is a process, not an episode or an event, and is unrelenting and exacting. The more people in prison, the better. It travels out to engulf proximate bodies and proximate social locations. I wish to draw attention particularly to the escalation of civic violence and civic impunity for dominant Hindu mobs engaging in violence in states ruled by the Bharatiya Janata Party. Also the brutal murder of committed public intellectuals, Professor Kalburgi, Gauri Lankesh, and so on. State impunity is nowhere as telling as in the deaths of Father Stan Swami and G.N. Sai Baba. Deaths as a result of gross mistreatment in custody. In 1977, when the Congress government was defeated and the Janata Party came to power, the Home Minister at that time, Chaudhry Charan Singh, was asked in Parliament to define custodial violence, because several people, Snehalata Reddy prominent among them, had died immediately after being released from custody. And Charan Singh at that time in Parliament, and this is in the parliamentary debates of the Lok Sabha, said custodial violence is any death that occurs within 6 months of release from custody. So just the fact of release doesn't mean it was not a custodial death. With somebody like G.N. Sai Baba, who was bound to a wheelchair, the time period of 6 months will extend through reasonable accommodation provisions considering his disability. So these are, in fact, custodial deaths. The equivocation of the courts is a crucial aspect of fortifying and legitimizing the weaponized carceral state. There are a few valuable exceptions, but painfully few. Dr. Ambedkar's statement is prescient. He says, I feel that the Constitution is workable, it is flexible, and it is strong to hold the country together, both in peace and in war. Indeed, if I may say so, if things go wrong under the new Constitution, the reason will not be that we had a bad Constitution. What we will have to say is that man was vile, unquote. We bear witness today to weak and timid courtly overtures on personal liberty, impunity, and state responsibility, and in quelling targeted assault and collective violence. The long satyagraha for civil liberties. It is important to deliberate on these contradictions and draw on critiques of state exceptionalism that have emanated from conscientious resistors, and we have had a long line of them in this country, rather than focusing on the reasoning offered by courts alone. For instance, the case of A.K. Gopalan may be best viewed through the lens of the civil libertarian challenge premised on human dignity to arbitrary government. The core aspect of this challenge was to push courts to interpret the new constitution in transformative ways, not in colonial ways, and to urge courts and governments alike to disrupt colonial habits of law enforcement and colonial ideas of the rule of law. It was only insurgent petitioning and political action that could create and sustain the possibilities of this disruption in a newly independent nation. And we see this in the early litigation on personal liberty in independent India. There have been small yet significant victories that swell the justice cascade, as for instance, the striking down of detention orders issued under the AP Prevention of Detention Act 1970 as being violative of the constitutional guarantee under Article 22(5) and under Article 19(1)(d) of the AP High Court, in the case of the detention of the Digambara poets Nikhileshwar, Charabandarazu, and Jwalamukhi. In the words of Justice Chinnappa Reddy, who delivered this groundbreaking judgment in the AP High Court, his judgment, he said, set right a retrograde step. This is one judge speaking about his own judgment, setting right a retrograde step and prevented the detaining authority, meaning the police and the executive, from making capricious or mechanical orders. It was absolutely essential for the detaining authority to found the order on clear and relevant grounds. Or from 1970, if you skip to 2024, you have the case of Mohammad Rahim Ali, alias Abdur Rahim versus State of Assam and others, where the Supreme Court, a bench of Justice Vikram Nath and Ahsanuddin Amanullah, restoring the citizenship of a Muslim man in Assam after 12 years, observed, I quote, "Nothing has come on record." This is this year. Nothing has come on record to indicate even an iota of evidence against him, except for the bold allegation that he had illegally migrated to India. It is also not known as to who, if any person, had alleged that the appellant had migrated to India. The court asked whether Section 9 on the termination of citizenship of the Citizenship Act empowers the executive to pick a person up at random, knock at his, her, their door, and tell her, him, them, "We suspect you of being a foreigner," and that then puts him in jail or denies him of citizenship. So also the recent judgment on bulldozers. We will find a scattered insurgent jurisprudence across courts of different jurisdictions across the country, and Justice Chandru has a whole bunch of stellar judgments in this regard. The importance of these victories is not diminished by the fact that later cases in the same courts on matters of preventive detention or on citizenship or any other issue of life and liberty did not or may not build on this jurisprudence. After all, the Puttaswamy decision, which was scripted by Justice D.Y. Chandrachud, remains a benchmark despite a slew of judgments by the Supreme Court and himself since, whittling down the right to personal liberty and fair trial to absurd levels. Nor one must we expect that judges will be consistent with their own prior rulings. We have seen this too over the past 70 years. What is important is that in specific clusters, so this is a point about how we read judgments, not that this judge is good and all his judgments are good, but in specific clusters of cases, petitioners and their lawyers have succeeded in shining the torch on the significance of liberties and dignity and have persuaded judges to walk their path. And that is the reason for hope. Embedded in these affirmations is the question of equal citizenship and its enunciations in resistance, demosprudence, state repression, and civic oppressions, all inevitably expressed through demands for an insurgent jurisprudence on the part of courts in every jurisdiction. From trial courts, so let's not forget the trial courts, from trial courts through high courts to the Supreme Court. The Supreme Court is not a one-stop shop for justice. We must begin with the trial courts. The goal is the accomplishment of a shared commitment to the spirit of the Constitution and its relation to citizenship, dignity, fraternity, and state practice. This notwithstanding the fact that the strong and workable Constitution that Dr. Ambedkar speaks of above is rendered in the likeness, and I quote Justice Narayanan here, in the likeness of a curate's egg, good only in parts. On the question of personal liberty, Article 21, which sits next to and overshadowed by the inexorable presence of preventive detention, Article 22. For it can scarcely be forgotten that Article 21 is designed to assure the dignity of the individual. So it's not just life and personal liberty, it is life with dignity, personal liberty with dignity, which is an unassailable right of all human beings. How and on what basis might we piece together memories that render the Constitutional workable, flexible, and strong, in ways that its preambular iridescence lights up pathways to hold the country together at a time when dominant political discourse reduces and degrades politics to the fractured banality of shards, tukde-tukde narratives. Accounts of civil liberties and human rights in contemporary India focus on the ways in which legislation, jurisprudence, and state action have historically entrenched practices of impunity, and on the regimes of radical evil in our present carceral times. It is widely acknowledged in scholarship on the Constitution that parliaments and legislatures have over 7 decades enacted counter-constitutional and therefore lawless laws. It is also widely acknowledged that courts have often taken easy resort to judicial harmony by standing with political power through a manifestly unjust jurisprudence that passes as constitutional. The latter, through omission and commission, has played a pivotal role in priming the ground to allow impunity as state practice to grow deep roots, even while both the courts and governments sing paeans to the glory of the world's largest democracy. I approach the question of fundamental rights and civil liberties, focusing on questions of law deeply riven with contradictions. It is in that internal rupture that we may glimpse a utopic, spelled with an E, a utopic possibility, despite the treacherous troughs in the journey. We could, extending V. Gita's account of Dr. Ambedkar's imagining of a third time, the utopic, argue that civil libertarians were taking a leaf out of Dr. Ambedkar's work in their persistent challenge to the certitudes of the political of all hues, even while finding new and imaginative pathways for the reasoning he proffered. This resilience of resistance is rooted in the interiorities and the unassailability of human dignity. Human dignity is not something that is granted. It is inherent and there and cannot, by definition, be violated. So what then surfaces in the assertion of the right to life and liberty is an assertion of human dignity as a basic value that cannot be derogated. This, I argue, enables a deep reckoning with this troubling history and helps think of obstacles to civil liberties as surmountable and reversible. I have not attempted here to provide a comprehensive account of lawfare and case law, but instead have indicated a pathway to give voice to silences as a way of making headway in decolonizing our present. My purpose is to keep the focus on what is not lost of the constitutional spirit and our aspirations for liberty as a people, despite the power of courts and governments to take easy resort to counter-constitutional laws. In this, I attempt an insurgent account of the civil libertarian attempt at destabilizing power and forging communities of resistance, multiple, plural, diverse, oriented towards creating a good and just world, not just in the distant future, imagined, not as a utopia, but in the here and now. How might we think of dignity as a moral and a constitutional value? A lens through which we may understand the loss of liberty and the significance of what Saila Ben Habib calls communicative freedom under the Constitution. This takes us back to concerns that were at the core of Mr. T.D. Narayanan's philosophy. This discussion on dignity draws importantly on intellectual traditions on the subcontinent and on post-Holocaustian standards in international law, notably the Universal Declaration of Human Rights and consequent connected standards. And it reconnects to my opening remarks on the Constitution as commons. While the constitutional articulation of dignity in the Constituent Assembly happens at the precise moment that the Universal Declaration of Human Rights is also being assembled around this very value, Upendra Bakshi argues that the Indian enunciation, far from being mimetic of Euro-American enunciations, was inspired by the many conceptions that circulated within and between the many struggles around dignitarian concerns against colonizations of different orders on the subcontinent, against British colonialism, against the colonization of caste, against the colonization of Adivasi communities, and so on. What might be the trajectories of recall, and how do we then harness this recall into reimagining what a convivial constitutional interpretation could possibly consist of? Remembering must begin with the insurgent spirit of struggle, the Ulgulan led by Birsa, and the memory of Birsa's Ulgulan, and Komuram Bhim's leadership of the Gond struggle for Jal Jangal Jameen, words and the memory of the struggle powering Adivasi resistance to this day. Satyagraha, for which Gandhi provided one articulation to protest against the colonial oppression of indigo farmers in Champaran, or to protest against the imposition of salt taxes in Dandi, for instance. For B.R. Ambedkar, Satyagraha was meant to establish our natural rights as citizens and human beings by dismantling the vested interests of caste Hindus in an iniquitous caste order. For Dr. Ambedkar, the Mahad Satyagraha, to assert the right to common waters, and the struggle for temple entry in Nashik, for instance. Maulana Azad provided an elaboration of the ontological basis of the Constitution of India on the Islamic principles of Tawheed, the oneness of God, not defined on the basis of homogeneity of all Muslims and their separation from all Hindus, but rather in terms of plural belief systems and alternative universalisms, if one may call it that, as constitutive of his imagining of self-rule. Each of these moves was part of a much longer, deeper politics of organizing, collective struggle, and theorizing of the possibilities for a utopic present and futures for an emergent nation. And we have, in fact, lost sight of the deep connections between these imaginings and our understanding of the Constitution today. All of this replays, for instance, in the mass protests before us today, although they may seem like small voices before the juggernaut of the post-truth state, and they force us to rethink the dialectical relationships between religion, castes, state, and citizenship in the very conceptualization of the Constitution, and reach a common ground of mutual respect, convivial living, and care that fosters the idea of a peoples. The idea of we the people in the preamble, liberty and Swaraj may be revalorized in robustly inclusive terms that reject assimilation and subordination through a retrieval of memory of vernacular moral traditions of building a shared history. And we have a rich and diverse vernacular tradition. fraternity and dignity, the core twin value in the preamble, builds upon a rich history of subaltern resistance and spiritual traditions that speak to ideas of fellowship and compassion. These are imaginings that sprang forth from the belly of injustice at different moments in subcontinental history as articulations of pathways to recuperation and renewal, contextualized in relation to the Hindu majoritarian present and the ways in which ideological formations today have shaped discourses around civil liberties constitutionalism. Most importantly, the ways in which our understanding of dignity and dignitarian wrongs and harms, the regimes of maiming, have been articulated in independent India. My attempt is a call to memory and a critique that illuminates paths not taken, recovering ground from shards that affirm freedom, fraternity, and dignity in a time of deep crisis. The purpose is to develop a cogent assemblage of citizenship that builds on histories of anti-colonial, anti-majoritarian struggles, assertions of the unassailability of human dignity that persists despite the rolling juggernaut of burgeoning exception. The affirmation of the right to life and personal liberty under Article 21, and I return to the title of my talk, sits at the core of the basic structure of the Constitution, in the light of which the enforceability of preventive detention under Article 22 may be reevaluated. The constitutional protections for Schedules 5 and 6 and Article 370 till 2019 provided the substantive normative check on the unceasing appropriations of homelands. The judicial discourse on the death penalty that narrates it as an exceptional feature, the rarest of the rare, in a rule of law democracy, is an argument that must extend to force the abatement of extrajudicial and custodial murders by the state with no legal redress. I'm speaking about encounters, which is in fact the death penalty by other means, since the officers almost never face prosecution and much less conviction for crimes committed in the name of law. And both our states, Tamil Nadu and the former state of Andhra Pradesh and the current state of Andhra Pradesh and Telangana, are notorious in implementing the death penalty by other means. The paradoxes remain, but therein also the hope. In the challenges that conscientious registers of different hues pose to governments and courts, and in the tenacity of ordinary citizens in reclaiming convivial spaces and building difficult conversations and socialities. It exists in the efforts to revisit our troubled pasts, and we reassemble insights of a moral firmament that speaks to the spirit of the Constitution, that rejects its aberrations, using legal arguments of severability and non-retrogression, it occurs to me, and provide a dignity compass for a just, compassionate governance, state formation, and citizen engagement in India for today and the future. Thank you.
Should we take some questions now? Any questions? Sit down. Would you like to sit down? Any questions?
Hello, ma'am. Ma'am, I'm a student of the Asian College of Journalism, and my question to you was regarding the recent trends in the Indian state providing the domiciliary justice and the whole purpose of providing vigilante justice within an instance. So, crackdown using machinery over people's homes have been trends far long as part of state's machinery. But what has occurred in the recent trends of public acceptability to vigilante justice? Why have we led to that part?
The, I have the same question. I have the same question. That you recognize that it is not acceptable by any standards to raise homes and dwellings and localities to the ground. And yet, not only is it being done, but there isn't an upsurge. Yeah? Because it is a form of targeted violence. So as long as you're not targeted, there won't be an upsurge. The point is just that. I mean, when we're talking about Article 21 rights, Article 21 rights are a unifying feature. So it should make your blood boil, whether you are targeted or not. Just the mere fact of somebody being targeted should actually make your blood boil. Why isn't that happening? And part of our understanding, I mean, some of us have been writing about it and speaking about it and going to court where it's possible, but we also know that courts have a very mixed attitude and profile. But the point of persisting in it, yeah, of which even the point of focusing on this in this talk is to say the way forward for the realization of fraternity or dignity or constitutional convivialism is a collective upsurge, no? And also the fact that when a particular state action is manifestly unjust, yeah, what is it that drives people to support a manifestly unjust act? And I can give you another example. In 2019, a veterinarian was sexually assaulted and murdered in Hyderabad. It was right in the center of Hyderabad, and three people were apprehended. There was no investigation. They were apprehended on suspicion. We don't know whether they are the ones who committed the crime. There was no investigation. There was no procedure followed at all. We were told that there were CCTV cameras that were perused. We now have a full commission report. The Sirpurkar Commission report is available. And we know that the law was flouted on every count. So you just pick up three people who are the poorest, most vulnerable, can't afford to even speak to a lawyer, uneducated, non-literate, and don't have a record of their arrest. Don't enter your vehicle numbers in the logbook, that the vehicle that was used to apprehend them. Put them in a guest house, not in the lockup. No record in the guest house. The CCTV cameras there don't work miraculously. And then you take them at 3 a.m. to what you call the site of offense and say that this armed posse of policemen, 3 men who had been in custody for 3 days, bearing no arms at all, made a murderous attempt to attack the policeman, and all three of them were shot dead. Yeah. So my question is, I, along with several people of my generation, have been organizing and protesting against sexual assault for 3 decades now. The major part of my work has to do with sexual assault and has to do with questions of justice around sexual assault. But even in my reckoning, this is not justice by any account. Conduct an investigation, apprehend people, put them through trial, convict them, hold them in prison. But you don't do that. And then the policemen were then feted. A large number of women congratulating them, no lawyers willing to appear for the families of the 3 men who had been shot. So you will see that the operation of vigilante justice all around you in very, very different forms and colors. Take the case of the remission of the convicts in the Bilkis Bano case. Yeah? So you can actually look at it. I mean, these were men who faced trial and were convicted for offenses. Yeah? So the point then is, how do we actually mobilize? Yeah? And how do we begin to talk about these questions within the framework of what we understand how do we understand the Constitution to understand these cases better? How do we own the Constitution? Own in the sense of a collective usufruct, not like in the sense of private property, but in terms of a collective usufruct, in terms of a collective ownership. How do we own the Constitution as something that helps us to make sense of this? And then how do we grow those ideas in the spaces that we inhabit? Yeah? Because resurgence is never something that happens out there. Resurgence is always something that grows within us, around us, and from there outside. Yeah? So, and that has been the character of movements for civil liberties. If you look at the history of civil liberties movements, that is what you see. Very ordinary people with a very ordinary education or no education, protesting profound harms by very powerful people and succeeding, sometimes at the cost of their own life. So it's not that it hasn't happened, but the point is that we are today at a time when it needs to happen much more. Yeah?
And ma'am, any comments on the judiciary standing on deliberately being late on addressing bulldozer justice matters pre-2021, but suddenly in an SC ruling coming up with a very procedural manner of curtailing those instant justice?
But procedural justice is extremely important. In fact, several of us have argued that the best way, I can't pronounce the new names of the criminal laws, so I'll just call it IPC and CRPC, after the Tamil Nadu High Court judge who also did the same thing. So, the best possible way to actually protect human rights is to follow the procedure laid out in the Criminal Procedure Code. If you follow that procedure, you do a fair bit of justice. You can then, of course, interpret sections in a more in a more expansive way. You can interpret it in much more proactive ways. But if you follow procedure, you don't fall foul easily. The problem is that there is no adherence to criminal procedure at all. No adherence at any stage. Yeah. So if they do cite procedure and they do say procedurally raising homes doesn't really, it cannot be given the stamp of justice. I think that's still a first step. It's very little, it's very late, but at least something. Like I said, you shouldn't look for large continuities. You will not get a large picture of justice. You will get little pieces, even in a single judge's trajectory. Justice Krishna Iyer, I know, he's known for being an advocate against the death penalty. And he was absolutely against the death penalty. But the last political execution in Andhra Pradesh, Kishta Gaud and Boomaya, he refused and sent back the file. And they were executed because the Supreme Court refused to entertain the appeal. Yeah, they were executed in 1975 at the height of emergency. You have Justice Chinnappa Reddy, who has given stellar judgments, so many, during the emergency, after the emergency, stellar judgments. There are still judgments of preventive detention during the emergency when he was in AP High Court, where he did not set the detainees free. So there are, which is the point, and these are judges of exceptional foresight, understanding of the Constitution. The point that I raised, that you need to understand that if you look at the entire trajectory of a judge's judging, you will find very, very few who will have a consistently good record on constitutional interpretation from the beginning to the end of their careers without a single wavering. You know, that unwavering commitment. You will have a very, very few. Otherwise, you will have several who have given very significant judgments, but then you'll always find that there is, a seesaw in their judgments. Which is why I think that, and I actually thought about this long and hard, and I think the way to construct, a robust understanding of human rights and the Constitution is not to look for consistency in a single judge, not to look for consistency in one court alone, but to put together all the judgments and all the decisions and all the reasoning that add up to a story. Yeah? So not to say, but this judge did this, he's hypocritical, he did something else. But to say, okay, as far as this goes, it's something valuable. And add it to a larger pool where you grow a body of jurisprudence. And for instance, if you look at the Puttaswamy judgment, I mean, I have a whole book on the Puttaswamy judgment. But, and there are parts to it that sometimes strike you as very hollow. But the bulwark of it is that they talk about dignity and they talk about reinstating the three major dissents, yeah, on preventive detention, on surveillance, and on ADM Jabalpur. And those are major. So you don't throw the Puttaswamy judgment out just because Justice Chandrachud compares the Dhwaja to the Constitution. You don't do that. Nor do you throw the Puttaswamy judgment out because he said he gave the Babri Masjid judgment through divine revelation. The Puttaswamy judgment has its place because of its reasoning. You just take it out of Chandrachud's entire basket and put it in another basket that you call, where you look at constitutional interpretation. Not by name, but by reasoning. Because these are not individuals, they act in the name of the court. So how does this reasoning alter our understanding of the ways in which we understand liberty and freedom? So you remove the personal from it and you keep the substantive. So then you're not bothered whether somebody is a rock star or not. You know?
Last question.
Ma'am, you were talking about basically how, as far as I could understand, it was like how the colonial nature of the Indian state is leading to these violations of human rights. So, but isn't colonialism itself driven by economic factors and capitalism, basically, which is serving the 1%, and the judiciary is benefiting from the system and is part of the system? So, how can we expect human dignity to be restored if we do not have like a systemic economic change as well?
Sure. So that's what we need to have, which is why you need to focus on the preamble. And that's why you need to focus on what anti-colonial struggles meant when they talked about the redistribution of land, the redistribution of resources, fair wages, mobilizing against economic exploitation. So the reason why, several might balk at the word, but socialist principles, and socialism is in the preamble. So the reason why I focused also on looking at the intellectual history of the Constitution, not just looking at the Constitution as a series of interpretations now, but looking at its intellectual history, is precisely to point to the ways in which one can harness those ideas into the present time. Yeah? The much reviled William Dalrymple actually, talking about the 18th century East India Company, talked about this intimate dance between the corporation and the ruler, talking about the princely rulers and the East India. That phrase was his, actually. And everything else apart, I think that's such an evocative phrase, which I have kind of adapted to say the coital embrace between the corporation and the government. Yeah? And that is really something that one needs to think through. And that is our present. I was just, while coming to ACJ, reading the latest Caravan issue on Nita Ambani. I recommend you read it.